it's great to welcome you back to our ongoing series treating the American Constitution. We're looking at the content of the Constitution. We're looking at something of the roots of the Constitution. And of course, we're considering a little bit the way in which it's been applied down through history. We're coming this time together to the Second Amendment, the Fourth Amendment, and the Fifth Amendment. So we're going to be making a little bit more progress in the Bill of Rights. And that's what we want to take up in just a moment. But I did want to add a footnote to the conversation that we had last time. I got an interesting response from someone. I was discussing, you may recall, the idea of religious freedom. And somebody sent me a message back and said something to this effect, anybody that advocates religious freedom is a heretic. And I thought, well, I guess that puts me in my place. But it did invite, I think, maybe a further comment on that. I don't know if that individual wants to keep listening to a heretic, so I don't know if that person will be participating from this point on. But you may be wondering about this little footnote that I'd like to add, which really goes back to something we talked about earlier. We said that in the Reformed view of things, which is derived from the Bible, but especially was emphasized in the Calvinistic wing of the Protestant Reformation, there was an understanding that in human society there are three areas of sovereign domain, beginning with the family, which is the most rudimentary. You might say it's the incubator of human experience, because in the family the child learns something both of government but also of the church. In the family, the child is encouraged to aspirational values, to do the best that the child can, but also is going to be brought up against those restrictions where the role of the family and the authority in the family is to set limits. In a sense, both the church and the state are functioning there in an embryonic kind of way in the family. But once we get beyond the family, we see that human society has those two different domains. There is the state and there is the church. Now, if you go to church, I want to make it clear, I'm not speaking of religious freedom in the sense that we've been describing it. The church is not supposed to be pluralistic. You don't go to church and hear the pastor say, okay, everybody, you can pick and choose what you want. If you believe that and disregard that, that's fine. A kind of sort of subjectivism that whatever suits you is just fine. That's not the message in the church. In fact, the message of the church, if it's faithful to the scriptures, is that you are not only invited, you are commanded to repent. You are commanded to bow the knee before King Jesus, because he is the non-negotiable sovereign of all history. He is the one of whom it can be said all authority was given unto him. He is ruling. He is at the right hand of God the Father. He is the name above all names. And you don't have any choices at that point, at least any legitimate choices, except to bow the knee before King Jesus and acknowledge his sovereign rule in your life. So in that sense, I'm not affirming religious freedom. When it comes to the church, the message of the church is quite emphatic on that point. The problem is, you see, in the church, we don't have the powers of coercion. We don't have the ability to pull out a sword and put it to a person's neck and say, okay, now you repent or else. That's not the legitimate ministry of the church. The weapon of the church is the sword that comes out of the mouth of the rider on the horse. The message of the church, the gospel that is preached by the church, is the power of God unto salvation. It is our weapon, but it's not a weapon that corresponds to the coercive powers of this world. And so when we go to the church, we hear the command to repent, but we also realize that we still have to make that choice freely. We're either going to bow the knee now in the context of repentance, or we're going to bow the knee later in the context of judgment. But one way or another, that is going to take place. Now, when it comes to the state, it's a rather different matter, isn't it? Because the state does have coercive power. The state can pull out the sword, as Paul says in Romans 13. The civil magistrate does not carry the sword in vain. And the very fact that the state has coercive power means the policy of the state should be religious freedom. Otherwise, the state is always going to be inclined to coerce people into a certain confession of faith. And it may be the right confession, it may not be. More times than not, the state, working in self-interest, is going to require people to confess to things that they may not really believe. You see, the potential for abuse there is staggering. And so when it comes to the role of the state, religious freedom should be the policy. That was derived from Calvin. I think it's a biblical view, and it seems to me that when we think about the role of the state, that's the right way to look at it. We read in the First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting or restricting the free exercise thereof. Notice it's a law addressed to Congress, the state. The state is not supposed to impose religious orthodoxy. It's the role of the church. What does the state do? The state restrains evil. The state makes sure there is an orderly society so that the church is not molested either by the state or by other forces as the church goes about her business. The church proclaims the gospel. The state makes sure that there's an ordered society out there in which the church can do so without external problems, you see, that get in the way, impediments. That's the ideal. That was certainly the view that was developed by Calvin, developed even more emphatically, you might say, in subsequent history by the Presbyterians of Scotland, the Puritans of England, and so on. It really was fundamental to the way in which the public policy was developed when we come to colonial America, and it was enshrined in our Constitution in the First Amendment. So, when it comes to religious freedom, I hope you understand, I'm speaking of the policies of the state. I'm not speaking of the policies of the church. And if that clarifies that point, then that's good. At any rate, at this point, I want to come to another couple of ideas that are somewhat controversial, especially the Second Amendment. We'll take a look at that. But before we do so, let's just have a word of prayer. Our Father, we're deeply grateful to you that you have given us the opportunity to survey the history of the way in which this nation was created and developed and some of the policies upon which it's founded. We pray that our conversation now would be richly blessed through the presence of your Spirit, that our discussion of these matters would be accurate and faithful, and that in all of it Christ would be honored. And for that we give you thanks. In the name of Jesus, amen. All right, well, we come to the Second Amendment. Of course, it's highly embattled these days. You're well aware of that. My task is not going to be so much to weigh in politically on the matter, but try to ask the question once again. What was the foundation for it? What was the understanding of it at the time that the Constitution was framed and that the Bill of Rights was ratified? Again, I'd have to say, if we look at the roots of the Second Amendment, it would go back to that Christian tradition which is founded in the principle of self-defense. It was understood that there is a natural right of self-defense. You can derive that from William Blackstone, who was probably the foremost jurist of the day, an English jurisprudential scholar, of course, a famous name. And William Blackstone quite openly and candidly acknowledged that he got it from the Bible. He went back to the principles found in Moses and his legislation in the Old Testament, and there's ample evidence there, of course, for the right of self-defense. Blackstone also had the idea that natural law would suggest that. You don't have to think too hard to realize that it is a natural order of things, that people should be able to defend themselves and defend themselves credibly. And so that would certainly lead to a notion that we find there in the Second Amendment. Probably the main debate, you might say, that's been connected with the Second Amendment is, does the provision of the amendment have to do with providing for the right of the individuals to keep and bear arms, or does the amendment only refer to military having the right to keep and bear arms? And you can see the problem immediately when you read the Second Amendment. Its language is as follows, quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Well, there you go. You know, you have the reference there to the militia. You have the reference to the state. And that does raise immediately the question whether or not the right we're speaking of is an individual right of individual private citizens, or is it a right that's only retained by the military? That debate has been bouncing around, of course, for a long time. The most recent examination of it by the Supreme Court is a 2008 case that was called District of Columbia versus Heller. In that case, there was a challenge to the very restrictive gun control laws that were in place in the District of Columbia, Washington, D.C., by a fellow named Heller. And so it gave the opportunity to the court to examine this issue once again. The counsel for the District of Columbia made what is a pretty conventional case, pretty predictable. First of all, saying that the reason that the Second Amendment is there was to clarify the rights that were enumerated for Congress back in Section 8, Article 1 of the Constitution. Now, you may recall that the enumerated powers there included several enumerated powers that referred specifically to the military. And the argument was that the power of Congress was therefore contemplated in the enumerated powers to organize, to arm, to set rules for, but also presumably to disarm the military. And the argument was that no, the Second Amendment is there to say that the military has its own independent authority because the freedom of individual states was at stake, and thus the right to keep and bear arms was not going to be inhibited or prohibited by the federal government. So they argued it was a clarifying provision in the Bill of Rights that had to do with the militia. The counsel for the District of Columbia also argued that the phrase "to bear arms" was ordinarily used to refer to the military at the time, and thus when it says to keep and bear arms, we should be thinking more of the militia or National Guard or some military sort of division rather than something that would be referred back to the people. The counsel for Washington, D.C. argued that even James Madison was clear that the phrase "bearing arms" would refer to military service. Counsel argued that even if there was ambiguity as to all of those arguments, the very fact that the Second Amendment makes express reference to militia would settle the matter in favor of construing the Second Amendment to be a provision relating to militia rather than to individual people. It's interesting, even during the oral arguments that were taking place, Chief Justice John Roberts raised the question and pointed out that the amendment does, however, refer to the, quote, right of the people, not the right of the militia. So even though you have a reference to the militia, the precise phrase in argument here was the right of the people, and that phrase, the right of the people, any other time it was used, was to refer to the people, not a military body. And so even during the oral arguments, you began to see which way the court may be tipping. The counsel for Heller, representing a more expansive view, challenging the restrictive laws in Washington, D.C., also noted that there's a difference in meaning between the word keep and the word bear. The phrase is to keep and bear arms. Bearing arms could properly refer to the militia, but to keep arms doesn't reasonably refer to military bodies. It would be more commonly approached as a word that would apply to individual people. Justice Scalia, when he wrote the opinion in favor of Heller when this was done, noticed that that very phrase, the phrase keep and bear arms, was actually originally used back in the Jacobite rebellion that involved the Scottish Highlanders. You may recall that the Highlanders were trying to restore a Stuart king to the English throne, and so they were rallying to Bonnie Prince Charlie, if you know that little chapter of history, and they were, of course, armed. And so the English Parliament actually passed a law, and the language of the law was going to restrict the Highlanders of Scotland from being able to keep and bear arms. That's where that phrase originated. That's what was being used at that point. Well, it's interesting that, of course, the language of the Second Amendment mirrors precisely the language that we used back there in the Jacobite Rebellion in connection with an attempt to disarm, and it would suggest, therefore, that the purpose of the amendment was to prevent government from disarming its people. The counsel for Heller also focused on the right of the people, as Roberts had said, which was always applied elsewhere in the Bill of Rights as referring to people, not to the military. It's also interesting when you look at the phrase, the keep and bear arms, that you can go back to the English Bill of Rights. The English Bill of Rights was put into place in 1688. If you're familiar with English history, you know that 1688 is a critically important year in English history. It's sometimes called the Glorious Revolution or the Bloodless Revolution. It was the point where the king who was ruling in England at the time, James II, was deposed and replaced by William and Mary. One historian describes what took place at that point in these words. In 1685, James II aggressively persecuted Protestants. If you're familiar with English history, you know the Puritan interregnum took place between 1640 and 1660, and then there was what's called the Restoration. Charles II came in and began to launch a pretty severe persecution of those who were formerly Puritans, Protestants. Even the Presbyterians up in Scotland were exposed to what was commonly called the killing times, in which it was really a horrible and ravaging time of persecution against people who were part of the Protestant Reformed tradition. Well, it only got worse when James II came to the throne in 1685, which is what's being referred to here. And of course, James II had a strong desire to disarm Protestants because he considered them a threat, and so they would have no ability to defend themselves if they were disarmed. James himself had a standing army. That, by the way, was the first time in English history that there was a standing army in England, and the Protestants were disarmed and thus had no ability to defend themselves against these efforts of persecution against them. Well, it was only 3 years later, says this historian, largely because of those abuses under James II, that the Glorious Revolution took place under William and Mary. You know, William and Mary. William was a Calvinist. He was Dutch. He came from Holland. He was a champion of religious freedom. He came in. He was married to an English princess named Mary. They were invited by English nobility to come in to depose James II and to take the throne there in England in his place. And so it's called the Bloodless Revolution because there was very little blood shed in the process. And it's a glorious revolution because it really did represent a great transforming moment in which you might say the English monarchy became a constitutional monarchy rather than what had been more of an absolute monarchy in prior times. That all took place under William and Mary. Now, it's notable that the monarchs, William and Mary, were welcomed on the condition that they signed what was called the English Bill of Rights. And one provision of that was that the people had the right to keep and bear arms. They had the right to keep and bear arms, and William and Mary, if they were going to rule England, had to subscribe to that particular right, the English Bill of Rights. Well, the Constitution was put into place about 100 years later, and it drew on the English Bill of Rights. And that was driven home by the fact that they had just fought a war with those same English authorities under George II that had been exercising such tyranny earlier under James II. And so once again, the idea that that phrase was being used in English history, that that phrase was being implemented now in the Bill of Rights, looking at the prior history behind it, the reasons for it, and looking then at the moment when the Bill of Rights was going to incorporate it, would certainly suggest that the same idea was in view. This wasn't a right that was being preserved for the military as such, but in fact it was intended for the people, and the people would have therefore the right to keep and bear arms independent of what the military had a right to do. Now, the only little problem in the Heller case was that it did not necessarily address the issue of what about the states. The Heller case, you know, came out of Washington, D.C. Washington, D.C. is not a state. Therefore, it's under the immediate jurisdiction and authority of Congress. And so the question of whether or not, this is kind of an important point, the question of whether or not the Second Amendment of the Bill of Rights was a constraint on the states or simply on Congress remained unanswered in the Heller case in 2008. The question really was more pointedly, were the states able to enact more restrictive laws than those found in the Bill of Rights? Maybe the Bill of Rights gives the people the right to keep and bear arms, but could a state, for example, pass laws that would be much more restrictive, effectively disarming the people? That was the question that still had not been answered at that time. Well, the question was answered in 2010, just 2 years later, in a case that was called the District, it was called McDonald versus Chicago, a 2010 case. And in that case, of course, we have Chicago, Illinois, a state, and thus that particular issue was raised at that time. It was at that point that the court really went back to the whole natural law theory that was undergirding the Constitution and the Bill of Rights. The idea that there were certain unalienable rights. The Declaration of Independence, of course, announces that as a philosophical foundation for our constitutional republic, that we are given by our Creator certain unalienable rights. The function of government is to secure those rights. Notice, to secure them, not to create them, not to give them. These are prior to government. Government's job is to secure those rights, and that was what the Constitution and the Bill of Rights were attempting to do. The court expressly reached that conclusion in the McDonald case, thus saying that the right we have there is not therefore exposed to restrictions by government, because in fact they come from God. They come as natural rights, not as government awarded rights. Really, Justice Scalia said as much back in the Heller case, but it took another case to really make that point clear. But in the Heller case, Justice Scalia, writing for the majority opinion, said, quote, "The very enumeration of the right takes it out of the hands of government, even the third branch of government, the judiciary. The power to decide on a case-by-case basis whether the right is really worth insisting upon." He says, "A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all." If it's a guarantee that can be modified later by a judge, then of course it's no guarantee at all. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures or, yes, even future judges think that scope was too broad. It's a powerful statement. Scalia saying, and of course appealing to that basic principle at the time, that the state is not God, and the state does not have the right to usurp the authority of God, and the right to self-defense is rooted in an idea of something that God has provided, and is therefore not to be tampered with by the machinations of governmental policies, that sort of thing. So anyway, at least as far as the Supreme Court is concerned at this point, I think you'd have to say that the Second Amendment is pretty secure. Obviously, there's still a great deal of political hostility to that. There are a lot of statists out there who don't trust law-abiding citizens with respect to their weapons. They want to disarm them. They try to do it in incremental measures, and we need to be on our guard about that. Whether you're a gun lover or not, we need to appreciate that there's a deeper and more powerfully rooted idea that's really driving the conversation at this point. All right, well, leaving that behind, we want to go to the Fourth Amendment, which has to do with being free from unreasonable searches and seizures. I'm skipping over the Third Amendment, you'll notice. It's not so much of a burning issue these days, although it was rather a burning issue at the time. It's the prohibition against having to quarter soldiers in peacetime. And there had been quite a bit of that going on during the French and Indian War in the years preceding the American Revolution, and there was still a pretty fresh memory of that kind of abuse in the minds of the people who were framing the Constitution. And for that reason, of course, they included the Third Amendment, but for our purposes, we'll leave it at that. I might just mention, however, that even the Third Amendment does reflect that Reformed tradition that there is a sovereignty to the home. The home is a sovereign domain, and government should not be able to just willy-nilly take over your home, that there's a independent sovereignty there that should be guarded, secured by government, not invaded by government. So even that amendment is rooted in that more classic idea. Similar thinking would go into the Fourth Amendment, which has to do with being free from unreasonable searches and seizures. If we think about the origins of that, it goes back to the English very abusive device that was called a writ of assistance. And out of that came a notion that there should be, with the people, a reasonable expectation of privacy. And the most important place where that reasonable expectation of privacy would arise would be the home. Once again, the family should be off limits to government intrusion in the vast majority of cases. There are exceptions we'll talk about, but basically, the home is a sovereign space, and the government shouldn't have the right to just willy-nilly invade into that place where there's a reasonable expectation of privacy. I might mention that reasonable expectation of privacy has been a little bit interesting in recent years because, of course, social media has caused a lot of people to disclose a whole lot of stuff that you wouldn't have expected them to disclose, and they do it quite voluntarily. I don't know how many times somebody wrote something rather unreflecting when they were a sophomore in college, that's something that would later embarrass them. And then when they applied for a job, 10 or 15 years later at a bank as a middle manager, something like that, that statement they made back in college comes back to bite them and they aren't able to get the job. It's been an interesting thing to see what's happened with social media, but that's really not the issue under discussion here. If you freely disclose something about yourself, then friends, it's out there, and that's a waiver of this. But there is still in the law this notion of a reasonable expectation of privacy. And certainly the colonists were very deeply aware of that at the time. As I say, there was the so-called writs of assistance that were being used by British authorities to basically walk into people's houses at any time, day or night, ransack the houses looking for alleged evidence of smuggling. You see, that was what was going on. No warrant was required. There was no probable cause that had to be shown. And this was the kind of thing that was happening. And the people in the colonies were pretty offended by that, as you can imagine. And they wanted to make sure that our Bill of Rights really addressed rather specifically that particular abusive power. The chief lawyer who represented the British in connection with executing these writs of assistance was a fellow by the name of James Otis. Now, James Otis, you may recognize as a name sometimes associated with the Founding Fathers. The reason for that is because he was so offended by the abusive practices of government and Britain among the colonies that he actually switched sides. And James Otis became an attorney representing the colonists against these writs of assistance rather than representing Britain in executing the writs of assistance. And so he was a very interesting example of a guy who kind of saw the light, along the way. On one occasion, he was in court and he gave literally a 5-hour speech defending the colonists against writs of assistance. I'm not going to read the whole 5-hour speech to you, but I do want to read one paragraph from it that is rather instructive. James Otis says, quote, "Now, one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. This writ, these writs of assistance, if it should be declared legal, would totally annihilate this privilege. Custom house officers may enter our houses when they please. We're commanded to permit their entry. Their menial servants may enter, may break locks, bars, and everything in their way. And whether they break through malice or revenge, no man or court can inquire. Bare suspicion without oath is sufficient." James Otis was really calling attention to what an abusive kind of practice it was to give authority to these writs of assistance because they were not based on any actual display of evidence of wrongdoing. They were simply a freewheeling attempt by the British to invade and search homes, private homes, any time that they wanted to. Well, these were the abuses that the Fourth Amendment was intended to prohibit. And the language of the Fourth Amendment makes that pretty clear, saying, quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." It's pretty straightforward. It goes straight to the issue of those writs of assistance, and it really has stood the test of time. It continues to be a very robust protection enjoyed by the American people to this day. A couple of questions remain unanswered in reading the Fourth Amendment. The first of them is, what is a search? What exactly constitutes a search? And the other one is, what's reasonable? So we have to get some definition of both of those. And fortunately, along the way, the Supreme Court has actually addressed both of those. What is a search? Well, a search is an invasion of an area where you have a reasonable expectation of privacy. As I said before, the home would be the place where we would most naturally expect that you would have a reasonable expectation of privacy. But we can ask the question, does that reasonable expectation apply in other places? There was an interesting case called Katz versus United States, which raised that very issue. Mr. Katz was a man suspected of being engaged in illegal gambling operations, and he would run his caper through a public phone booth. So he would go out and close, these were back in the days, of course, of the little enclosed space, a phone booth. He would go in there, close the door, it's a public phone booth, and then he would engage in his illegal gambling operation. Well, the government was suspicious that's what he was doing, and so at one point the government installed a secret listening device in the phone booth in order to gather evidence, which indeed they did, and on that basis they arrested Katz and accused him of the crime that he was allegedly committing. Well, Mr. Katz had a smart lawyer who said, wait a minute, that looks to me like an invasion of a place where you have a reasonable expectation of privacy. The state said, well, what's a reasonable expectation of privacy have to do with a phone booth? It's out there on the public sidewalk. How could that possibly rise to that level of protection? But the court actually agreed with Katz and said in its opinion, quote, the Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own house or office, is not subject of Fourth Amendment protection. If you freely disclose it, then it's out there. But what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. If you intend to keep it private, then there should be privacy that attaches to it. The argument was that Katz had a reasonable expectation of privacy, even though he was in a public phone booth, because he was closing the door. He was acting in a way that would suggest that's what he was attempting to accomplish. So that invasion of a space where he had that expectation was a violation. Now, as I say, the place we normally think of as the most natural expression of this would be a home. But again, it's a home because we're acting as we're in a place of a reasonable expectation of privacy. Even the home can be a place where that right is waived, you see. There's a case, I think it's a little bit of a funny case actually, but it's Minnesota versus Carter. There was a fellow who was a drug dealer, and he did an illegal drug transaction in his living room, in his home, where he had a reasonable expectation of privacy. And there was an exchange of money, a big pile of cash for several bags of white powder, that kind of thing. And so he thought he was safe because he was doing it in his home. But as it turns out, he had left his living room windows open. And so a police officer was casually walking down the sidewalk, glanced in, and saw something rather suspicious. A big stack of money and several bags of white powder, And on that basis, the police officer went and got a warrant and came. And when later the challenge was raised by Carter as to whether or not that warrant was legitimate because he was in his home and he had a reasonable expectation of privacy, the court said, well, sorry, but if you're going to leave your curtains wide open so that anybody standing outside on the sidewalk can look inside, then you have waived your reasonable expectation of privacy. Well, how far does that go? Another case was Kylo versus the United States. In this case, law enforcement came along with a fairly high-tech piece of equipment that was thermal imaging equipment. And they could basically sit outside on the street and scan the house. And in doing so, they discovered what amounted to grow lamps inside. They got a warrant on that basis. When the person who was the owner of the house, Kylo, challenged that, the court said, well, sorry, not so fast. It's one thing to look through an open window, that's where the curtains have been drawn back. It's another thing to have kind of a high-tech scan of your house that you were not aware of. There's no way you could have prevented it in the first place. Your reasonable expectation of privacy was in fact violated at that point. So that search warrant was illegal. You might be thinking, well, yeah, but the person was a wrongdoer. Shouldn't they go to jail for that? But keep in mind, these rights that we're talking about are not primarily to protect criminals. They're primarily to protect you, you see. These rights are there to keep a tyrannical government from invading your space. And that's what we should be thinking of. Now, the fact that it accrues to the benefit of criminal elements is just the nature of the case. How else are you going to enforce these things unless you give them actual enforcement powers? And so we need to bear that in mind. Sometimes you'll hear people got off on what's called a technicality, you know. But actually, many times those technicalities are actually the constitutional protections that have been wisely placed there by our founding fathers. And we should be grateful for those technicalities because while they may exonerate a criminal from time to time, they are there for our good, and for that we can be grateful. Well, we looked at the question, what is a search? Another question is, what is reasonable? What's reasonable in connection with a search? A search, to be reasonable, is supposed to be based on a search warrant. A search warrant is a document that's signed by a neutral judicial officer, usually a judge, who puts his name to it, and he puts his name on a warrant only on the basis of probable cause. Probable cause means that in the judge's mind, more probably than not, there has been wrongdoing. The law specifically declares that law enforcement was come before the judge and present articulable facts. Articulable, that means these are facts that can be announced to the judge, not a hunch, not a gut feeling, you know, something like that. There have to be actual facts that can be reported to the judge that wrongdoing has taken place. And in addition to that, there have to be articulable facts that the wrongdoing that's taken place was perpetrated by the person who is to be searched. That's what gives rise to a reasonable search. So it has to be based on probable cause, and those are the elements of probable cause. All right. Is it ever possible for the police to enter your home without probable cause, without a search warrant? Answer, yes. You know, if a police officer comes to your door and simply asks permission to come in and search around, and you give consent, then at that point no warrant is necessary. It's a moot point because you've given your consent, and so the person can do so. Now, I'm going to give you a little legal advice here. You know, I'm not a practicing lawyer anymore, but I'm going to suggest to you that if a police officer ever does come to your house and ask to search around, that you should decline it until a search warrant is provided. There have been many cases where people have given this permission and regretted it. Not because illegal findings were there in the house, but because once the police have your consent, they can pretty much ransack your house. And there have been people that have been highly offended at the way in which the police have gone through their house once they gave consent. And sometimes it can happen in unexpected situations. I'm aware of cases where, for example, some parents are homeschooling their children. Okay, nothing wrong with homeschooling, but if you have a malcontent neighbor who doesn't like you or your Christian faith or something like that, there have been cases where a neighbor has called in an anonymous tip to the police saying, you know, I think there's child abuse going on in that particular house, and they'll give the address. An anonymous tip. Well, you get an anonymous tip of child abuse, you need to follow up. The police come to the door and ask to search your house. They don't necessarily have to tell you what they're searching for, why they're there, but they can simply ask for your consent. And as a matter of fact, if you give consent, then you may regret it, not because you are found to be guilty of some crime, but because you've just had your house trashed by people looking around for some evidence of some kind of wrongdoing. My point is, you're much better off to simply politely decline it. It's always a good idea to ask for a warrant because that forces law enforcement to do its job before a search can take place. The other exception that's notable in connection with searching without a warrant are called exigent circumstances. This would be in the case of an emergency, or maybe there's just been a criminal act that's taken place and some criminal runs down the street and runs into your house. If the police are in hot pursuit, then they don't have to get consent to enter in that situation. Again, it has to be truly exigent circumstances. It can't simply be bare suspicion or allegations. There has to be something that actually gives them what would amount to eventually articulable facts that they could report to a judge to justify the search that they undertook. I might just mention once again, an anonymous tip would not constitute such evidence. I'm happy to report to you that at least in connection with the Fourth Amendment, the way in which that amendment has been applied down through history has been pretty consistent with what the Founding Fathers envisioned. They had recent memories of writs of assistance. They were trying to guard against them. And I think in a general course of things, the Fourth Amendment has been a good bulwark against that kind of abuse. Well, the last thing I want to look at in our conversation today is the Fifth Amendment, and particularly the Fifth Amendment, which has to do with the use of what's called due process. Due process. The due process has to do with a fair trial. And once again, you have to say there's a tradition that goes back into the Reformed tradition and through that to the Bible with respect to due process. The most enlightened lawgiver of the ancient world was Moses, writing in round numbers around the year 1500 BC. Moses gave standards of due process that still provide a model for jurisprudence to this day. Up until the time of Moses, probably the most enlightened lawgiver was a man named Hammurabi. Hammurabi's idea of due process was, if you're accused of a crime, we throw you into the river. If you drown, you're guilty. If you're able to swim out successfully, you're innocent. Now, I'm going to tell you a little secret. By normal standards of due process, that's not very impressive. But that was what was used, and he was the most enlightened thinker, you see. It took Moses to come along under divine enlightenment to give us what still remains to this day a pretty decent standard for due process. It was in the Reformed tradition especially that those ideas were worked out in detail, and certainly you see that in England, you see it in Scotland, and we see it worked out in the colonies. And that's why due process has a meaning to us as we think about the way in which it's provided to us. What is due process? Back when I was a kid going to school, sometimes my teachers would say when I was doing a math problem that I need to show my work. You ever heard that expression? You got to show your work, Well, what does that mean? It means the teacher can go back later and make sure you didn't just accidentally get the right answer, that as a matter of fact, you were able to work through logically from the problem to the solution. In a sense, you might say due process is the requirement that the police show their work. The work of the police is supposed to take place according to the rules that apply, and the rules are spelled out in the Constitution, and the application of those rules is called due process. I know that I'm a great supporter, of law enforcement. I love the police, and I'm glad they're out there. But even saying that, I think that the potential for abuse by people with law enforcement authority can be rather significant, and so it's good that we have these rules of due process. The possibility of abuse is well documented. We have many occasions of it where we've seen examples, and so we should be very glad that there is this provision of due process. It protects people who have been falsely accused. It protects us from places where our freedoms might be attacked by government overreach. All of this is part of the reason that we should be grateful for due process. What are the elements of due process? You've all heard it. If you watch any TV detective shows, you have the right to remain silent. What's the root of that? Well, the root of it is that the burden is on the state. You don't have to prove anything, at least initially. All you're doing is simply, being detained by the state. The state has the burden to inform a person of the charges against that person, to give that person a fair hearing, a public hearing, in which the evidence is going to be presented, and that has to take place and the case be successfully proven before anybody can be deprived of life, liberty, or property. This was an answer to what had taken place back in England under what was called the Star Chamber, if you recall that. One of the most abusive devices of ancient England was the Star Chamber, in which a person could be tried and convicted without their knowledge. You could have a trial of an individual that was taking place in a secret, so-called smoke-filled room, you know. A guilty verdict could be achieved, and the person could be arrested, and that's the first they heard of it. That would be an egregious violation of due process, because due process requires that the person be advised in advance of the charge against them and given an opportunity to respond. So there has to be this proof that a person has violated the statute or the law, and an opportunity for the accused person to give an answer, to provide an alibi, to provide some kind of alternative explanation for the appearance of the facts, and so on. That's what due process suggests. The state has a very heavy burden at this point. It has to carry a substantial burden, providing credible evidence against the accused. The burden of proof that the state has is the highest in our system of justice when it's a criminal act. In civil acts, civil litigation, basically it usually is the case that sort of a probability, more probably than not, would be sufficient to make the case. But when it comes to a criminal accusation, there's a higher standard. A higher standard would be something like clear, cogent, and convincing, but even that falls short of the mark when it's truly a criminal prosecution. In a criminal prosecution, it's necessary to prove beyond a reasonable doubt. Beyond any doubt that has any reason to it. That's an extraordinarily high burden that the state has to prove that a person is guilty of a crime. The bias in the law has always been that we would rather have 10 guilty people go free than one innocent person be punished for a crime they didn't commit. I'll grant you that rule doesn't always, isn't always applied as consistently as it should be, but that's certainly the bias of the law, and that's something we can be grateful for. That's what due process involves. If a person is found guilty, then they should have an opportunity to explain, or they should have explained to them, I should say, exactly why the guilty verdict was found, and all of that constitutes elements of due process. Now, I might mention that, the amount of due process you get may vary a bit depending on the seriousness of the crime. If you're being accused of a capital crime for which the death penalty might attach, then obviously you should be given the highest level of due process. If it's a parking ticket, then maybe something less than that. But nevertheless, the whole idea is that there should be this due process, that should be part of the system that is working in connection with your determination of guilt or innocence. When is due process due? Well, it has to be in advance. There has to be prior notice that you are being subjected to this procedure. The case of Cleveland Board of Education versus Loudermill said, quote, "An essential principle of due process is that a deprivation of life, liberty, or property be preceded by notice and opportunity for hearing appropriate to the nature of the case." So prior notice is required anytime the court, or the government, I should say, plans to deprive you of life, liberty, or property. I might mention that property is not simply your tangible goods lying around your house there, but property can extend beyond to certain other benefits in life that you may enjoy. It can extend to educational opportunities, to employment. Interestingly, it can also extend to welfare. The General Welfare Clause of the preamble of the Constitution provides this provision for general public goods. Now, that's been, as I've argued elsewhere, I think extended a little bit beyond what the framers envisioned, but nevertheless, that General Welfare Clause is there. And that also has been understood as an area where a property interest can arise. This was rather a sea change in the law that took place back in 1960 in the case of Goldberg versus Kelly, in which welfare ceased to be a charity and began to be an entitlement, you see, and that was a rather significant change. The court said, quote, "By hypothesis, a welfare recipient is destitute, without funds or assets. Suffice it to say that to cut off a welfare recipient in the face of this kind of, quote, brutal need without a prior hearing of some sort is unconscionable, unless overwhelming considerations justify it. From its founding, the nation's basic commitment has been to foster the dignity and well-being of all persons within its borders. We've come to recognize that forces not within the control of the poor contribute to their poverty. Welfare, by meeting the basic demand of subsistence, can help bring within the reach of the poor the same opportunities that are available to the others to participate meaningfully in the life of the community. Public assistance, then, is not mere charity, but a means to, quote, promote the general welfare and secure the blessings of liberty to ourselves and our posterity, borrowing the language then from the preamble of the Constitution. Well, that was a turning point, you see, because as I say, it was the point where you might say that welfare went from being a charity to being an entitlement. We've talked about entitlements before. The Constitution specifically prohibits titles of nobility, but we have brought in the back door certain titles which entitle a person by definition to government benefits, and that is one of the things that's being envisioned here, of course, by this particular change in the law that took place in 1960. So now welfare payments can give rise to a property interest, requiring due process before those welfare payments might be cut off. You've heard of the Miranda warnings. Miranda was a case that took place some years back. It really changed the meaning of due process in connection with police interrogations. Before Miranda, due process simply meant that the police could not use highly coercive techniques in their interrogations. But after Miranda, it required the police to become teachers, to actually educate people who were accused of their rights. You have the right to remain silent, you know. You have the right to an attorney. If you can't afford one, one will be provided. People may not know that intuitively, although if they watch a little TV, they probably have a pretty good idea about that. But those Miranda warnings were intended to give to people an understanding of what their rights are. They're good rules. I wish they had come from the legislature rather than the court, but nevertheless, that's the rule that applies, and it's probably good that it does, and it's part of the expression of our overall idea of due process. I might add, footnoting an earlier comment, I wish a similar rule would attach when police come to your door and want to look around and ask for your consent. They should probably be required to tell you, you don't have to grant your consent to our search. Many people don't know that. They just realize that if the police are asking it, they're supposed to give their consent. That would be a conversation for another day, but nevertheless, the principle of due process certainly has been useful to us in the broad sense. So anyway, that's a quick look at the Second Amendment, Fourth Amendment, Fifth Amendment. Again, as I've said before, I think all of these can be traced back through the Reformed tradition to the understanding of civil polity that was developed in that tradition. And of course, all of them really can be fairly easily traced back to biblical sources as well. And so when we say that we're given by our Creator certain rights that give rise to these kinds of protections, then of course that's a reasonable thing for us to be affirming. And we should be grateful for the tradition that gave rise to those expressions of our civil liberty in this nation.